all the members of the bar. It's always homecoming for me whenever I stand in front of you. And I have golden memories of the time that I spent somewhere around this complex, because mostly it was in the Ram Mohan Palace as a lawyer, which most of the youngsters wouldn't be knowing about. So we are here to commemorate a very historic event which took place on the 4th of July, 1776. To go down memory lane, to have a good look at the present and imagine the future, to better understand the immutable values which underpinned the Declaration of Independence. A little bit of history to begin with. When I said I will go down to memory lane, because it's important to understand the context in which the declaration came about. We've always had waves of colonization in the world history. It was Portugal and Spain which pioneered the colonization which took place, started in the 15th century. And Christopher Columbus, whom we always associate with the discovery of America, he didn't really reach America. He went, the US as we know it, but instead he touched the Caribbean islands. So he went back to the king of Spain and told him that there's actually not spices there, because actually he thought this was a spice route. That's which you find in the East Indies, including India. And there was another Italian explorer who found out what is today Spanish Florida. Again, under Spanish rule, they went into. Then there were the Swedes, the French, and the British came, with whom we are concerned. For the first time, they established. The first colony was in Virginia, that is in Jamestown in 1607. I am relating these dates for the purpose because it will have a bearing with what I am going to tell you and the comparison with the Indian constitutional history. The last colony along the east coast of the Atlantic coast was actually Georgia, which took place in 1732. So starting with 1605, and you had 1732. The people who went to the colonies always were armed with a charter issued by the British Crown, which essentially set out almost the rights and privileges which were available to Englishmen in England. It was made available to also the Americans. Therefore, basically, they were British subjects, in short. Now, they were always, as I said, blessed with a charter from the king. There are three kinds of charters, actually. The company charter, the corporate charter. You had the proprietorship charter, and then you had the royal charter. In the case of the royal charter, it was the king or the government in England which would appoint the governors, because they had the institution of governors for the colonies even then. In the case of proprietorship charters, the proprietors would actually have the governor. And the company, the corporate charters, it's a company in England which would actually pull the reins of government from England. Now, these colonies were actually founded for various reasons. Many people went with a commercial aim at heart. Many were Quakers or Puritans who were fleeing the recently established Anglican Church, because as you know, when King Henry VIII came, and when he wanted to divorce his first wife and he wanted to marry Anne Boleyn, so the Catholic Church, which was then in control, actually opposed the marriage. And so King Henry VIII said, that's enough, you have had enough time here. And Protestant Church, with Martin Luther had already, in 1498 with the thesis, 96 theses, he had come forth with the Protestant belief. And so he said that we established the Protestant, which is why it's called established church, because it's got the blessing. The king is, in fact, at the head of the established church, the Anglican Church, the Protestant Church. Protestant churches are there in all of Europe, but in England it's called the Anglican Church. So when the Protestant Church actually came about, a lot of people who were not satisfied even with the kind of reforms which the Protestant Church, the Anglican Church had brought about in England. They said it must be more pure. And then you had the Quakers. They got a name from the fact that you have to quake, tremble in front of the Word of God, that you are not leading a good enough life. So were the Puritans, the very name suggests. You have to purify yourself even more. And therefore, there were different brands which actually rebelled against the Protestant Church in turn. So you have a lot of history of religious intoleration building up under the Protestant Church. Now this goaded another group actually to go and settle down in the United States, which offered freedom, toleration. So these were the reasons which took them there. So to the west of the 13 colonies, you must understand the 13 colonies. At the north, they're called the New England colonies, Massachusetts with Boston, where much of the historic events would happen. And then you have the middle colonies where New York, New Jersey, and so on and so forth. And then you have the southern colonies. We have North Carolina, South Carolina. You have the redoubtable Virginia, which was the first colony, as I mentioned. And then you have Georgia, which brings up the rear from the south. So when these colonies had French territories on the west, you had further west, you had Spanish territories because they're also colonized. You also had, we should start with the Native Americans. They were around thousands of years. So when the people from England went, one of the reasons, the colonies were set up was to spread Christianity. Because they felt that it is important that you should preach Christianity, and they called the Indians savages, which today, you would shudder to things in the universal human rights regime that we have. But they were, in fact, in writing black and white, you find these words, savages. And there was always skirmishes and violence and wars between them. Now, what happened was, France and England were at war in Europe and the rest of the part. Like I said, England joined the bandwagon of colonization late. But interestingly, by 1922, the British Empire had around 22% of the land in the world under it. It had become the largest empire in the history of mankind. So Britain and France fought with each other, the World War, and actually it all started somewhere in 1756. And you find the reflection even in India under the Battle of Plassey, which you will recall. It was with the victory of the British over the French that they were able to essentially consolidate the rule of the British East India Company, which, as you know, again started with another charter issued by the Queen in England. So Britain had a very comfortable win over France. And Britain also had to fight on behalf of the colonies against the Indians and the French in the west of the East Coast, where you had all the 13 colonies. America was not what it is today. It did not have the 50 states which it has today. It just started off with 13. And then finally, after a period of time, they first acquired Louisiana from the French by a $15 million purchase. And likewise, treaties and wars, and finally it is what it is today. The long and short of it is that every war costs money. And the French, Anglo-French war also cost a lot of money to the British. So the British had to raise revenue. The British came out with the Stamp Act of 1765. The 1765 Stamp Act actually levied stamps on papers, newspapers, court papers. So this actually aroused hatred and anger among the Americans. So what they said was, they said that we do not have representation in the British Parliament because we don't have any representatives for obvious reasons, because of the Atlantic Ocean which separated them, and you couldn't possibly have an MP which is geography oriented. So the British said, no, you can't, because in theory in England, every member of a parliament, irrespective from where he is elected, he represents the interests of all. You have Birmingham, for example, at that time, which was not represented. So he said, no, every member actually represents every other part of the country, and they represent the Americans as well. So you don't really need a representation. But it is here that you must realize that much of what really flowed thereafter and culminated in the Declaration had its genesis and origin in the 1215 Magna Carta, which, as you know, King John granted a number of rights to the barons, 75 in number, who had rebelled against him. And so one of the rights was that you should have representation. You can't raise taxes. And this is amplified in the Petition of Right in 1628, the 1689 Bill of Rights in England, and then you have the Parliament's Acts of 1911 and 1949, which pretty much makes up what is the unwritten Constitution of England. So this representation, no taxation, protests, and now we are in the midst of protests in India. From what I will be telling you, you will realize that remaining supine and without response when injustice after injustice is heaped on you, it really does not make you a democracy. Protesting, dissenting, expressing your opinion strongly is the fundamental basis of democracy. And this is what the Americans have shown. So much so that protests went to such an extent that the British Parliament actually repealed much of the Stamp Act in the next year, 1766. But they took care to again bring out another law called the Declaratory Act, because they didn't want to lose the legislative power to tax the colonies. So they said they retain the power. So then, there in 1767, you have yet another act passed by the British Parliament that increased the range of products on which the taxation fell. Steel, various products from came to be taxed by the British Parliament. So that again triggered yet another wave of protest among the members of the colony. Even though you must realize that much of the revenue which was sought to be made up through these taxes were necessitated because the British took sides with the colony in the fight against the French and the Indians. So the British had a justification for what they were doing. So in 1770, you had what is called the infamous Boston Massacre. 9 British soldiers fired on a crowd of 300 to 400 Americans. 5 died. 5 died in 1770. You know how many died in Jallianwala in 1919? Around 1,000 died. Keep all this in perspective, how different people respond differently to how they are treated by particularly an alien group. So 5 died, and this again set up a huge wave of protest among the members of the colony. Violence took place, and the British again responded with the Stamp Act, the Tea Act. The Tea Act proposed to impose a levy on the tea, which was actually being procured by the American traders from Europe. So what the British had in mind was they were actually getting a lot of tea from the British East India Company. They wanted to dump cheap tea on the colonies, cheaper than they were able to import from Europe without the taxes under the Tea Act. So this led to again a huge convulsion, protest. Not only protest, around 400 Americans dressed as Red Indians conducted what is called the Boston Tea Party, where they jumped onto a ship and dumped large chests of British tea into the sea in Boston. Now, this actually prompted the British Parliament to come out with what was called the Intolerable Acts, which is a slew of laws which were passed by the British Parliament to actually, see that the colonies actually fell to their knees and obeyed the British Parliament. Far from it, it only led to the first Continental Congress, which actually consisted of delegates from all the 13 colonies. It was held in September of 1774. Then you have the 1775 kicking off the Second Continental Congress. Now, after 1775, the Continental Congress, what it did was, from 1775 onwards till 1783 is shown in the history as the period of the American Revolutionary War. 1775, they decided to raise an army. I'll repeat it. The Americans decided to raise their army. They were making preparation for a war with their mother country, England. Then they met, and by the time Virginia, one of the colonies, had already brought up its own constitution. In fact, the Declaration is supposed to have been inspired largely by the Virginia Constitution, the state constitution. So, once the army was ready, in June 1776, 3 resolutions called the Lee Resolution, named after one Mr. Lee, who proposed these resolutions, happened. One of the resolutions was that the colonies are free. They declared themselves free. The resolution was actually moved on the 2nd of July. It is actually the 2nd of July which should be celebrated as Independence Day. But the Declaration of Independence is celebrated on the 4th of July, 2 days thereafter, for the reasons that the Declaration actually contains the grounds on which the Declaration of Independence was made on the 2nd of July. And that is how it became famous, as we all today know. So what really did the Declaration do, and what were the underpinnings, and what provided the political, philosophical basis for the Declaration? For that, you have to go back to John Locke, the great political philosopher who actually published his 2 treatises on government in 1689. Again, he was a British man. So he actually espoused essentially the ideals of equality, liberty, and property, estate. These were the 3 words which you keep in your mind. In the midst of the violence and the struggles which the colonies were going through, you had the likes of Thomas Jefferson, whom Jejuba correctly described as a lawyer himself, and one of the most widely well-read persons. It is said that he had several libraries, would sell one after the other, then he would acquire more. So we would always, he has read Epicurus, the Greek philosopher, who you all know as the philosopher who espoused the principle of hedonism, pleasure, seeking pleasure. It would find its underpinnings in the Declaration, as I will be just revealing to you. So when there was a committee actually constituted to frame the Declaration. And the committee, knowing the inclination of Jefferson to read and understand and think, and being a lawyer, he was actually assigned the task of preparing the first draft. So he made the first draft, it was vetted by the Committee of 5 and finally approved by the Continental Congress. So in the treatise, in the Declaration, you will find that it is actually addressed to the world opinion. The first paragraph of the Declaration says it is addressed to the world opinion. And then it goes on to declare the iconic words today, which echoes across continents and over time, that we believe these truths to be self-evident. that all men are created equal, that they're all endowed with certain inalienable rights, which include life, liberty, and it should have been property. If you went by Locke, he substituted with the pursuit of happiness. This is traceable to his belief that pursuit of happiness is perhaps more dignified and it is more encompassing, and it is a catch-all expression which is capable of being stretched. In fact, historians who have studied say that even the persons who drafted the declaration were not aware of the momentous impact it will create later on in history. But it's the hand of God, as somebody would say, whatever it is. So I'll just point out some of the salient features of the declaration so that you'll get the importance of the declaration. You find that the declaration was actually drafted by Christians. Why I say Christians was, you find the word used, all men are created. At a philosophical level, if you see, Hinduism does believe, of course, that Lord Brahma created. Buddhism, for example, does not believe in the idea philosophically of creation. Jainism does not believe in creation. That it never had a beginning and it goes on. So I'm just pointing out what is the perspective or the context in which they said that all men are created equal. You will notice that if it were to be actually made today, feminists would immediately take objection to it. The expression men, as in fact it happened during the formulation of the UDHR, that is the Human Rights Universal Declaration of Human Rights. When the first draft said men, all men are equal, a woman from Punjab who was India's representative took objection to it. And thereafter it was converted to, instead of men, it became all persons are entitled to equal rights. So at any point of time, at the point of time when the declaration came out, which was in 1776, the Christian belief that prevailed. So all men are created equal. So there is a creation and all men are equal. There is no reference to women. And then it goes on to say that they are endowed with inalienable rights, which not confined to life, liberty and pursuit of happiness, which include. So that left the window open for the entry of unenumerated rights, as we call it today. And this is the theory of natural rights, which John Locke and his ilk exposed. That these are rights with which every human being is endowed by birth, by mere reason of the fact that you are a human being, you are also blessed with rights at the time of birth. In fact, the theory of Robert Locke was, which was prevalent even in the time of the Greeks, that when you are all born, all babies, you are born a clean slate. Your mind is a clean slate. What gets written into it, what you make of your life, is essentially the experiences through which you go. It is these experiences which actually make you unequal. Otherwise, the belief, according to Jefferson and the theories that he believed in, was God created everyone pure, equal, and therefore there is no inequality at the time of birth. Now, this is in respect of, this is a theory of natural rights. John Locke also believed, you must kindly realize, that the theory was that every man owns every part of his body. You own your own body. So how does property come about? Property comes about because by exercise of labor, when you work with your hands, with any part of any organ of your body, what you acquire, because it's an appropriation for the general good, it becomes your property. It's taken out of the common dominion and it becomes exclusively the property of the person who has actually spent his labor on it. This is a theory except for the Lockean proviso. There is a theory of Lockean proviso which he also... So he said that except that if there is not enough in common, where, like for example, desert, and there's you get water from a source there. And if one man is going to find it and he says, by my labor I have found it and nobody else should get it. So Locke doesn't agree there. So that is the only exception. Otherwise, Locke valued property as an extension of the human personality. And that is how the theory came about, the natural rights, and they are inalienable. You will recall that in 1959, our Supreme Court has declared that fundamental rights, which are actually natural rights, as held in Puttaswamy, cannot be waived. A citizen cannot waive his fundamental right for this very same reason, that you cannot part with it, because it is this is a duty actually. It's more than a right, it is a duty for you to, for example, protect your life, to protect your liberty, to preserve your right to pursue happiness. So this is the natural rights part of the declaration, which is very important. The second part which stands out in the declaration, which must commend itself to all generations of mankind, is that it explained the purpose of government or as a state. The declaration goes on to say that the purpose of government among men, association of men, is only to secure these inalienable rights for everybody. It's a right-centric approach, and it is intended to see that the state actually does not interfere with anyone. Basically, the laissez-faire argument, which Adam Smith in The Wealth of Nations actually proclaimed. And if those of you are interested in the later development, if you see Robert Nozick, I would recommend that you would buy that book and read it. It's called Anarchy, the State, and Utopia. He was an American philosopher, 1938 born, 2001 died. In the midst of it, he propounded the theory of property, which he said, actually following Locke, that property is an entitlement, that if you acquire it lawfully, no state can take it away by way of redistribution. So this is a kind of theory, and the state's role is again defined in the declaration. This is what I wanted to point out. The third important aspect of the declaration is that the declaration goes on to say that if the state actually were to not follow its principal purpose, which is to protect the rights, then the people have a right to change the government, to revolt against the government. These are the three things that should be done, can be done. This is the importance of the declaration. Now, the importance of the declaration doesn't end there. And why do I say that? What followed? You see, in 1776, the declaration was made on the 4th of July. America went for war with England, with its mother country. It had raised the army, as I had said, in 1775. It went to war. As part of preparing for its own form of government, it actually prepared what's called the Articles of Confederation in 1777, the very next year. Put together what's called the Articles of Confederation. You may ask, what is a confederation? How is it different from a federation? In the case of a confederation, it is the constituent units, which is the 13 colonies, or the states, as you may call it, which are really more important than the center, the federal government. So, 1777, the Confederation, Articles of Confederation was ready. But it required Maryland, one of the states, to ratify it in 1781 for it to come into force, actually. In 1778, one of the principal purposes for which the declaration was made came to be fulfilled, which what the Americans had planned, which is this. You see, if the Americans, as members of the British Empire, were to go against the British Empire, they would be dubbed as rebels and could be put down. If they declared themselves as a sovereign state, which is what they did in the declaration, they could aspire to get allies in the world and support from world allies. And not unnaturally, France, which is the chief enemy of England, came forward with a treaty in 1778 itself. The France, therefore, fought with the Americans, and finally, in 1781, almost the war actually came to an end. Of course, it took 2 more years in 1783 to conclude the Treaty of Paris, which is the second treaty, the Treaty of Paris, under which the British Empire actually recognized the United States. So kindly mark this period of time. 1776, they declare themselves independent. They go to war with England. The war lasts till 1781. And in 1783, the mother country, the sovereign which actually held sovereignty over the American colonies, recognizes the Americans. They didn't wait for Satyagraha. They didn't have peaceful marga. They went to war, fought it, won their independence. So 1781, they had this confederation going. This is a loose kind of a federation, as I've explained, where the center is weak. The weaknesses of the confederation became very obvious because we had the Shays rebellion. Some of the British colonies rebelled against taxation not by the British Parliament, but by the government through the Congress. So finally, they decided to have a different form of government, which is a federal government, where the federal government would become powerful. And this is how you had the 1787 Philadelphia Convention at the Philadelphia Hall, the very same hall where they had the earlier confederation. And in 1787, you had the confederation, and 1789, the United States was born. But you had a lot of reservations being expressed by the anti-federalists, because they felt that the rights of the individuals are not indicated in the Constitution of the United States. The interesting part about the United States Constitution is, it is so brief, it's incredible. It consists of only 7 articles. Kindly contrast that with 395 articles to begin with of the Indian Constitution, which made it the longest constitution in India after Alabama, which was the state constitution, and actually followed up by, of course, the Bill of Rights in 1791. So the Constitution did not provide for individual rights, so they decided to have the Bill of Rights. Now, you may think that in the aftermath of this momentous declaration, which is such a gift to mankind, there were no problems at home, that everything went well in the United States. I'll just mark 3 aspects before I come to what happened in India. As I said, all men are created equal in the declaration. When it came to drafting the Constitution, they had to provide for the manner in which and the number of people who would get voted into the Congress. The Congress consisted, as you know, of the House of Representatives and the Senate. Each state was to send 2. There is no variation, unlike we have in our Rajya Sabha. Every state, irrespective of size, population, will send 2 senators. House of Representatives had to be chosen directly by the people. Now, what would be the electoral college look like? So what happened was, in the southern states, it was mostly agricultural estates, where you had actually the slaves brought from Africa working. 40% almost the population of Virginia and the rest of the southern states, there were African Americans who were working as slaves. So there was a problem. On the one hand, of course, you couldn't give them the right to vote. That's out of the question for the white man. But you needed to count the number of African Americans, so that if you decided to have the number of representatives based on the population, the southern states could get more representation. So the people in the north said, no, you can't have that way. You can't count the slaves and you don't even give them the right to vote. And mind you, in the northern states, they became the first states in history of mankind which had earlier slave laws, that is, which permitted slavery, they became the first states in the world to abolish it. Because they were largely into manufacturing, unlike the southern state, which was into agriculture, which required slaves. So the colonies, United States, became what is known as divided into slave states and free states. This is how it went. In the Constitution, what they did was, in the Constitution, mind you, you will not believe it, they hit upon a compromise which provided for what is called the 3/5 compromise. The 3/5 compromise consisted of this formula. If you have 5 slaves, if you have 5 African Americans, you would not count the whole number 5. You would count 3/5 of 5, which is 3. So in that way, they struck a balance. So this is a stain which has continued to haunt the US Constitution. And people point fingers at, the very founding fathers, because Washington himself was a slaveholder. President Jefferson, he owned slaves, a large number of slaves. So slavery has existed for thousands of years. In fact, there's a historian, Gordon Woods, one of the chief historians on the Revolutionary War. He says, actually, you can't look at it, as we look at it today, completely aghast at it, because this is an institution which has been there amongst mankind for thousands of years. So what the northern colonies did was revolutionary. Abolitionists and others didn't do it because they had to have cheap labor for working their farms. So this the Congress came to be constituted on the formula of 3/5. And then I will leapfrog to the Dred Scott case. Dred Scott happened in 1857. Dred Scott was actually an African American slave who fled from a state where he was held as a slave to a free state. And then he filed a case in a federal court, initially in a state court where he was unsuccessful, claiming that actually he is entitled to be freed because he had been to a state where there was no slavery laws. It went to the Supreme Court, unfortunately by 7-2. Chief Justice Taney, writing for the majority, took the view that an African American is not a US citizen. Mind you, what a stark contrast with all men are created equal. Only I would rephrase it, all white men are created equal. Okay. So then the next phase is 1861 to 1865 under President Lincoln. You all know the Emancipation Proclamation, the fresh declaration of independence by the Confederate States in the South, because they said that we are actually, parting ways with the Union. And Lincoln would have none of it, obviously. And so went to war, and finally the war was concluded in favor of the Union. And from 65 to 1870, you had what is called the Reconstruction period and the Reconstruction amendments to the Constitution. Now, what were these amendments? The 13th Amendment abolished slavery. The 14th Amendment is, of course, the most litigated article and the most quoted article, perhaps in all jurisdictions all over the world. But the 14th Amendment actually provided in Section 1 for actually 4 things. It provided for citizenship for all, except, of course, for the native Indians who were not taxed. There's another history. Then you had the Due Process Clause. Then you had the Equal Protection Clause. And finally, you had the rights and privileges which the US citizen had could be enforced against the states, because that was a big dichotomy, that the 5th Amendment to the Constitution actually provided for various rights and immunities to the against the federal government. So argument was the states are not bound by the 5th Amendment. So to make clear that the air there, they brought in the amendment making the rights and privileges available to against the federal government applicable also to the states. The second section of the 14th Amendment also did away with the 3/5 clause. So you would think that is the end of it. The story ended, everyone went home happy, and there was no more slavery. Far from it. You had the Jim Crow laws. White supremacists say they couldn't imagine, wildest dream, that their slaves would come and vote in the same booth. So you have, of course, Plessy versus Ferguson, 1896, where the court, with one dissent of Justice Harlan, the court declared it's good enough to comply with all these amendments if you treat them equally, even though you treat them separately. Equal but separate was accepted by the Supreme Court. Again, one of those unfortunate judgments of the Supreme Court. As far as the slavery aspect is concerned, you will find that they introduced certain laws to see that the slaves didn't get to vote. They included insisting on tests to be passed, taxes being levied on everyone, and they also brought in a grandfather clause. It's called a grandfather clause because what they said was, all those people whose grandfathers voted before the Civil War, their children would have the right to vote. And of course, the African Americans didn't have grandfathers who voted. So they were kept out while the whites went on to vote. They had a field day till in Ginn versus state of in the US in 1913, the US Supreme Court struck it down. Even there, the story didn't end. It finally took the Civil Courts Act, the Civil Act of 1964, at the time of President Johnson, I think. And thereafter, another judgment in 1966 by the Supreme Court, which struck down the poll tax, that finally the decks were cleared for the African Americans to exercise their vote. In other words, it took nearly 190 years after the declaration which you are talking about so much in their own home country, for them to recognize their fellow human beings who had worked on their farms having the right to vote. This is one flaw which must be flagged. The other flaw is, as I said, women. Women had the right to vote in some of the colonies prior to the declaration. But by 1807, New Jersey was the last state which abolished the right to vote for the women. Then what happened? So they went to court. They relied upon the 15th and the 16th Amendment, race, color, 14th Amendment. US Supreme Court said no. It took the federal Congress to pass the 19th Amendment, which came into effect in August 1920, for the women to gain the right to vote. The native Indians, they have a peculiar system because they have 456, if my memory correct, tribal colonies where they have semi-sovereignty. So if they live in that colony and if they don't pay the tax, they would not get the benefit of the right to vote. This is how they were excluded in the Constitution. Finally, in 1924, the Indian Voting Act was passed, by which the right to vote was given. Now, therefore, this is a kind of a short history of how it played out in the United States, the land of its birth. Now, what is the global impact actually? The moment the declaration was published in newspapers of the day, which is the only means of public communication, actually saw to it was published in the papers. The copies were shipped across to Europe. It spread like wildfire. And not unnaturally, France, by the way, when it supported the colonies, it in turn incurred a huge debt. It had a lot of internal fissures which actually blew out, and then you had the French Revolution. So when you had the French Revolution, they came out with what is called the Declaration of the Rights of Man and the Citizen. Now, they have largely borrowed from the American Declaration, inspired by the American Declaration, to rebel against I would like to just read out 4 articles, which I thought is important. Men are born and remain free, equal in rights. Social distinction may be founded only upon the general good. The aim of all political association is the preservation of natural and imprescriptible rights of man. These rights are liberty, property, security, and, mind you, what brings up the rare, the resistance to oppression. Liberty is explained in Article 4. Liberty consists in the freedom to do everything which injures no one else. Hence, the exercise of the natural rights of each man has no limits except those which assure to the other members of the society the enjoyment of the same rights. I read out these passages only to explain how the French have refined the understanding of liberty as the right to do without limit whatever you wish to do, so long as you do not cause harm to another, which is the famous John Stuart Mill's no harm, the harm principle, that you don't cause harm to others, you are free to do whatever you wish to do. The only exception we find in the modern world is if there is a direction to calling upon you to wear the helmet, you could always say that, it's my head, what is your problem? Except the insurance company could always say that does cause harm to me. You will have to pay for the extra. Or somebody standing on the footstep of a bus and traveling. And if he dies, that is my life. But the modern legislature has, modified this, harm principle in a slightly different way. The fire of independence was also carried to the next neighboring geographical entity, which is South America. South America, for the most part, was under Spanish rule, except for Brazil, which was under Portuguese rule. Now, starting with actually, I think it is Colombia in 1810, Venezuela in 1811, all these countries were actually following the footsteps of the American counterparts. They declared independence. They had fights. They actually went to war with Spain because Spain had by that time become a spend force. It had spent so much of money on the wars which had been waged. So finally, Southern Europe, gradually actually imbibed the spirit of independence and freedom and gained independence. It also spread to Europe, actually. And finally, because of shortage of time, I will only refer to Ho Chi Minh, 1945, the Vietnamese great leader, who actually decoded the declaration in his own words. He said, all the peoples are equal from birth. All people have a right to live, to be happy and free. This was his version. So you will find the reflection of these values finally captured and articulated in the Universal Declaration of Human Rights. You might be wondering, when you've read the phrase, all men are created equal. And the question is, are men really created equal? We all today know that genetically we are not equal. Physically we are not equal. We have different faculties. Some are born with handicap. Some are born with such handicaps that they cannot really exercise any of the rights which. So what really is equality in law? What really is the equality that is promised to us? That has been articulated, expatiated in the French Declaration, which I said, and in the Universal Declaration, because it says you are equal in your dignity and rights. Everybody is having equality in the matter of rights. Because you are a human being born in a particular community, you are in a particular area or nation, the UDHR, the United Nations Declaration of Human Rights, which really epitomizes, the universalization of these values, it declares that you have the rights everywhere. Now, I think time to come to of the Indian context. The Indian context is a little bit of history. The history, as you all know, somewhere in the 16th century in Surat, British came as a trading company, the East India Company, established their first post, and then as I earlier mentioned, the 1757 Battle of Plassey consolidated power, and by 1857, you had a British India which consisted of roughly 2/3 of the undivided India. The rest of undivided India actually consisted of about 700 princely states, which included Travancore and Cochin, unlike Malabar, which was actually part of the Madras province. So the East India Company made various advances. Legislation was passed under the British. And finally, you had the first war of independence in 1857. It lasted till somewhere in 1858. And the British force was obviously more organized, and they crushed the local rebellion. We had local revolutionaries like Rani of Jhansi and very heroic figures who tried to put up a fight, but we lost. 1858, we had the transfer of power to the Crown Act passed by the British Parliament, by which British East India Company was taken over, and the affairs of British India was directly to be dealt with by a ministry in the British government. So, if I asked you to conjure up what would have happened if the same thing had happened in America, they would have gone to war. They would have persevered. India remained splintered, disorganized, weak, soft, because we had our own ambitions, and the British had their own way of dealing with and manipulating and getting the best out of us. Finally, we had in 1885 the Indian National Congress being established. Alongside, the British also did their part, because the Labour government supported the British Indian cause a little bit. Labour Party, sorry. So we had the Indian Councils Act, first somewhere in 1869, and the last of it was in 1909. A little bit of democratization. And then you had the Government of India Act of 1919. There was a time, as you remember, the First World War was fought. And the Indian leaders actually sided with the British for the most part, because they said that, okay, we will go along with you, but you give us dominion status. They did not give us dominion status, but they gave us the Revolt Act, a law which was so harsh that we had the Nagpur Resolution in 1920, where we actually hit back with a promise of civil disobedience. In 1929, because of lack of time, 1929, we had the Indian National Congress holding its meeting at Lahore. And on the 31st of December 1929, to be precise, they hoisted the Indian flag on the banks of the river Ravi in Lahore. They had prepared a resolution. The resolution was read out on the 26th of January 1930. They said that this is a Purna Swaraj declaration. And I would like to just read out to you a small portion. We believe it is the inalienable right of the Indian people, as of any other people, to have freedom and to enjoy the fruits of their toil and have the necessities of life, so that they may have full opportunities of growth. We believe also that if any government deprives a people of these rights and oppresses them, the people have a further right to alter it or abolish it, lifted from the Declaration of Independence. The British government of India has not only deprived Indian people of their freedom, but has based itself on the exploitation of the masses, and has ruined India economically, politically, culturally, and spiritually. We believe, therefore, that India must sever the British connection and attain Purna Swaraj, or complete independence. Mark the difference in words. This was projected as an aim that we should obtain, whereas the Declaration of Independence is that from today we are declaring ourselves that we are going to war with you. This is the contrast that you will find. Why I am saying this is, it took 17 years after the 1930 declaration, that in August 15, a few days from now, you get the independence that you talked about. So you had, immediately after the 1930, Gandhi was furious, so were other leaders, that we didn't get the dominion status. You must also understand an aside. Australia and Canada had obtained dominion status, which is why the Indian leaders kept on clamoring for dominion status at least. Australia, Canada under the 1868 British North America Act, and where it was finally chiseled into greater autonomy for the Canadian legislature by the Statute of Westminster in 1931. And the Canadian Constitution finally giving the Bill of Rights happened in 1982, where they completely severed their connection. And Australia also in 1986. This is how it happened. So they were actually given the dominion status which India was denied. For some reason, India was not ready. This is what the Britisher would always say, you're not good enough for democracy. At times, we do think that, are we? That's a different matter altogether. So immediately after the 1930 declaration, we had the roundtable talks. In 1939, the Second World War happened, and we had it continuing until 1945. And in 1942, Gandhiji came out with the civil disobedience movement, that Quit India movement. That hastened the process a little bit. But you had Stanford Cripps coming with the cabinet mission plan. And in 1946, we had Nehru as the interim prime minister. We had the interim government from 1946. We also had a constituent assembly put into place. The Indian Independence Act was passed in July 1947. Many people think that we actually gained full independence. Actually, we gained only dominion status under the Indian Independence Act. We still had till January 26, 1950, Governor Generals being appointed by the Crown. Though sovereignty as such, the right of the Indian government to legislate to make laws, of course, was given to and British Parliament did not have power to make laws for us. That's true. The Indian Independence Act, in fact, recognized the existence of the Constituent Assembly as having the power to make laws, legislature, and this is how 2 years, 11 months and 18 days, the Constituent Assembly sat from 1946 onwards, debated, and we have finally, you have 26th of January 1950, where we really became a republic, completely free. So in the course of the Constituent Assembly debates, the members definitely relied considerably on the declaration of American independence. What happened under the Constitution? So for instance, unlike the American context, which the Chief Justice rightly pointed out, it is completely different from what obtained in India at the time when we actually became independent. And what is that? See, at the time of the declaration, as I pointed out, we were talking about essentially a Christian white population concerned about their rights, natural rights, property rights, and so on and so forth. They were not facing problems of huge poverty. They didn't have the depressed classes, which you're talking about, the scheduled castes. They didn't have the backward classes. They didn't have minorities. They didn't have multilingualism. There are so many languages, dialects. Multi-religious, multilingual, everything, diversity. Though we have unity in diversity, it's very sublime, good to say all that. But the cup of woes never end for a country to be governed with so much of diversity, so many conflicts which are always there, which come to the fore. Which is why when we drafted the Constitution, in the preamble actually, we start off with to secure to us justice, social, economic and political. Then it's followed up by equality of opportunity, then freedom, liberty, and then finally fraternity. This equality, liberty and fraternity is actually taken out of the French Constitution. So we have actually, motley mix of ideas which we have assimilated from various world constitutions, as it were. But the similarity between the American Constitution is, we have actually taken much of their fundamental rights. We have borrowed a lot of their fundamental rights. For example, the First Amendment to the US Constitution, as I said, 4 clauses. It consists of 4 clauses. It says that you shall not establish any church because, as I said, they were running away from Protestant oppression. So they were very clear that you should have a wall separating the state from the church. You cannot also suppress the expression of religious feelings. That is the second clause in the First Amendment. So that is a free, which is what is contained in Article 25 of our Constitution. Correct? Then third, you have free speech. You have free speech in America, which is sought to be transplanted as Article 19(1)(a) in our Constitution, but with Article 19(2). And with Ramesh Thapar versus State of Madras, coming in the very first year of the Republic, Parliament didn't have any other alternative but to bring in the First Amendment, to introduce the word public order, because the Supreme Court said they were trying to actually put down the publication on the ground there was public order, but public order was not one of the heads under which Parliament could make law and regulate free speech. So they introduced public order. Today I have heard some speakers on the television decrying the inclusion of public order, which is why we have lost the original free speech which we actually lifted from the American Constitution. But in our country, a certain modicum of regulation perhaps was necessary and is still necessary. Then you have the Equality Code in Article 14(16), which actually is essentially lifted from the 14th Amendment, which I mentioned, equal protection of the laws. When it comes to the due process, B.N. Rao, who was a constitutional advisor, was a man of outstanding merit. I mean, the hats off to him, who prepared the real first draft before the drafting committee actually took it up. And Dr. Ambedkar was actually chairman of the drafting committee. But he had the rough draft prepared by B.N. Rao. So B.N. Rao actually interacted with Justice Frankfurter of the US Supreme Court. And Justice Frankfurter told B.N. Rao, please don't put due process clause in your constitution. You will run into a lot of trouble. Starting with the Lochner judgment in 1905, where a law which provided that bakers cannot work for more than a certain number of hours, labor laws, were struck down because actually it was found that the freedom of contract is actually property. So that is being taken away. Until 1932 or so, this, till Holmes theory actually prevailed ultimately of deference to the legislature. So we didn't adopt the due process, and we know what happened in A.K. Gopalan because of that. And finally, through Cooper, R.C. Cooper, the nationalization case, and finally in Manega Gandhi, we have established that the procedure must be fair because of the interplay between Article 19, 14 and 21 and all that, which all of you are very well aware. In fact, we have in place of substantive due process, actually we have progressed to a stage of the triple talaq case, where even legislation made by the sovereign legislature can be struck down. All that, 2 or 3 judges even have to find that there is manifest arbitrariness in their view. That's good enough for the court to strike down the law under article in the Indian jurisprudence. Unlike in America. America, you have different kinds of review depending on the subject matter. Rational review, strict review depending on the rights involved. That is how they have evolved. But what I'm saying is that we have essentially followed the pattern of equality, liberty contained in Article 19, which is fleshed out in greater detail, as you know. But so many rights which have been expressly culled out in Article 19. And then 21 speaks about personal liberty and life and where it is. Article 22 is actually, it stands out as a sore thumb because you don't find a counterpart for preventive detention in the United States. I just checked up, subject to correction. You can have judicial detention, which means in a particular stage of a trial, criminal trial, if the accused would normally have been let out on bail, the kind of heinous crime that he is accused of, the court may decide not to release him. So he is not yet found guilty, but he can be detained. Short of that, in England, in the US, you didn't have a provision for preventive detention. But, we had the Government of India Act, which we have essentially followed in our constitution. The difference is that the Government of India Act didn't provide for fundamental rights, obviously. We came out with the fundamental rights only for the first time in the Constitution. So Article 22 is a problem. Then you have Article 23 Begar, and then you have these rights for the minorities. You don't find a counterpart for these, the minority rights as such in the US. Because around the time when the Constitution was drafted, there weren't any minorities. Unless you can think of, the Dutch or the French being minorities compared to the Anglo-Saxons, which is not the case. So they don't have these provisions. The Indian experience, Indian problems apparently persuaded the founding fathers to actually draft the Constitution the way they have done it, because they had to deal with this huge problem which they knew was coming, and which did come in the form of the terrible violent partition which took place, which showed their apprehensions about, the communal discord that can, shape up, and which happened also. Now, let me just have a glass of water. We have the role of the Supreme Court in the matter of unraveling and finding and discovering and declaring unenumerated rights, starting with the 1993 judgment, where relying upon Article 41 and 46, which are directive principles, and reading Article 21, they discovered and declared the right to education in P. Unnikrishnan versus State of Andhra Pradesh. Thus began, in fact, what began actually in Francis Collin in 1980, where they actually laid the foundations of the dignity jurisprudence. Dignity of the man, the citizen, is at the core of the Indian Constitution. So every other right, in fact, even in the Declaration of Human Rights and the International Covenants of Civil and Political Rights, which constitute the Bill of Rights, International Bill of Rights, do you find that the word dignity always shining? And there are no limits to what this dignity jurisprudence can really achieve over a period of time. It continues to be an ongoing process where you can unravel even more new rights. So you have the right to privacy, which is declared by the Constitution bench in the Puttaswamy case, the larger bench, the judgment, which incidentally relied upon natural rights, just like Keshavananda did. Even in Keshavananda Bharati, in fact, the individual judges have actually had a very vivid exposition of natural rights. And fundamental rights are natural rights, which means they are not given by the legislature. They are not given by man to man. They are rights which are innate, which are actually recognized by the Constitution. It's only a recognition which takes place under the law. So, you have now developed to the stage where, in the same-sex marriage case, the court has, of course, not followed the American counterpart in Olgo, I can't pronounce it, but you know what I mean, the judgment where the US Supreme Court recognized the same-sex marriage. So, we have actually, in other words, kept close breast with the developments in American constitutional law. We have borrowed several ideas from American constitutional law. In fact, even in Sukhdev Singh versus Bhagat Ram, the theory of instrumentality of state was actually an idea which was borrowed from America, and which today enables employees of public sector corporations to actually avail of fundamental rights and other rights again through a writ petition. All of this is actually as a result of the American Constitution, as I pointed out, consists of just 7 articles, and over a period of 235 years, 27 amendments only. India, over a period of 75 years, starting off with 395 articles and then expanding into 448 articles today, has had 106 amendments. So this actually is a pointer to actually one or two things. And the first thing is, please do not actually glorify anyone to the point that you make them infallible. When you actually, try to cover anyone with infallibility, the problem is you will have a lot of controversy in trying to demystify their actual contribution. The founding fathers worked in 2 years, 11 months and produced this document, massive document. Despite so many, that's not a perfect document, which is proved by the fact that it had to be amended 106 times. Their contributions are seminal, and that has to be acknowledged by us. And you should realize another statistic which will actually shock you. In America, they did a study as to what is the average life of a constitution in the world. They found out it's 17 years. So the fact that the US Constitution has lasted this long, the fact that the Indian Constitution has lasted 75 years, is a testimony to the fact, the sagacity of the founding fathers, as much as, of course, those who have worked it, perhaps less of the latter, more of the vision that we have. Now, I would like to end by actually pointing out certain concerns that I have. The first concern which I would like to flag is the problem of defection. Now, I just try to check up whether you have defection in Western Europe, whether you have defections in United States. In United States, it's called switching. It did occur occasionally in the United States, but in the early part of the 20th century, almost vanished. Western Europe, it is almost unheard of. Italy has a little bit of problem with that. Look at our country. Look at the kind of defections which have been taking place in our country. Everybody in this country should be shocked at what is happening. We do not know where the truth lies. We hear about carrot and sticks. We hear about the ED being used. We hear about large sums of money being pumped out. It happened in Maharashtra. It happened earlier also. It is happening right in front of our eyes. Would the American revolutionaries who had fought and won independence have kept quiet if they had seen this being done to their motherland? I am certain no. But we allow it to pass by. We allow it to pass by, notice it for a few, news flashes, news discussion. Everything is normalized. Now, let me tell you, in 1985, by the 53rd Amendment to the Constitution, we have the 10th schedule. Such a thing is absolutely, such a constitutional amendment was absolutely unnecessary. But why? The movers, A.K. Sen, who moved the bill, he said that you have a real problem of people changing, voters actually, vote you under a particular party and a particular philosophy, that you will expose that. That is what they believe in. That is democracy. And mind you, the words of the Declaration, that the fundamental purpose of government is to actually protect the rights, inalienable rights. And the government will have the right to continue only as long as you have given your consent to it. In other words, consent is fundamental to democracy, because consent is the basis of social contract, which is propounded by Rousseau, propounded by Locke, all the philosophers. Otherwise, we are all free. We have a right to be free and to decide things for ourselves. The moment we give up some of our rights so that we get some of the other rights, it means that we are consenting to it. Are we consenting to the kind of murder of democracy in the manner it has happened? It is happening. And it goes, and I must actually, share my angst that members of the associations do not actually articulate, ventilate the grievances, because you are the noblest and the most learned profession in the country. If you do not actually take up arms against this kind of, showing the Constitution, all the constitutionalism, constitutional morality, all very fine, noble tools we have fashioned, but all of it goes down the drain. And all those who have actually violated the 10th schedule, as I would understand, which is the allegation, and this is where the problem arises, which is the next problem which I am going to flag. The problem is, once this happens, the 10th schedule provides for a mechanism, as you all know. Aggrieved party can file a petition. Petition is to be filed before the Speaker. The Speaker must take a decision. The Constitution, the 10th schedule, does not provide for a time limit. So what happens actually? What has happened so far? I will just refer to 3 or 4 cases which I found, and that makes, not only interesting reading, but shocking reading. In one of the cases, which was decided by This is P.K. Balasubramaniam writing for the bench. That is Rajendra Prasad Rana in 2007. The BM, that is the party in Uttar Pradesh. Yes, that party. 13 members. They actually petitioned the speaker, asking the speaker to call the opposite party, because the Bhagavad Samaj party decided to dissolve. 30 members wanted the opposite party to be called to form the government. This act actually immediately led to a petition filed for disqualifying on this ground, that this is actually a clear case where actually they are switching over. The matter was before the speaker. Speaker didn't do anything about it. In the meantime, what happened was, the members actually brought about a situation where they could lay claim to the 10th schedule protecting them because they had united together and they mustered enough numbers for allowing it to pass muster. Speaker said that is true. Therefore, I will not decide the original 13 members' disqualification. This reached the Supreme Court. The Supreme Court said this is an abdication of power by the speaker. And the court, in fact, did not remit it back to the speaker. The Supreme Court itself actually went on to declare that this open invitation to the members of the opposite party to form the government constituted an act of defection. They were disqualified by the court. Rajendra Prasad Rana. Then, what happened is, in Paddy Kausik Reddy, and thereafter in S.A. Sampath Kumar, please look up, S.A. Sampath Kumar, the question arose before a two-member bench of the Supreme Court as to whether the courts can dictate a timeline to the speaker to actually decide the anti-defection petitions. The court on 8/11/2016 said that this is a matter which should engage the attention of a constitution bench. Matter was referred in 2016. So that happened in that way. In Kesam Megachandra, 2020, Volume 2, Scale 329, 3 members of the Supreme Court, speaking through Justice R.F. Nariman, actually found the facts of that case. Again, there was an abdication, and the court directed the matter to be concluded. Even though the matter relating to whether the court could direct a timeline was pending in the Constitution bench, the court said this is a clear case where the court said concluded within 4 weeks. Finally, on 31/7/2025, which is the latest, Paddy Kausik Reddy, judgment by Justice Gawai, on 31/7/2025, facts were stuck from Telangana. Persons who were elected from a particular party, they switched over and defection was incurred. The opposite party, the BRS, actually, the BRS were the petitioners. They went to, the speaker filed a petition. The speaker did not issue notice even for 7 months, kept it in his file, obvious reasons. Siding with, I think the Congress party was in power then, had come to power there. So they went to court, and finally it reached the Supreme Court. The Supreme Court actually directed it should be concluded within a period of 3 months. Now, what has happened to the Sampath Kumar case, which was referred to the Constitution bench some 10 years back? So I checked up, subject to correction. If I am wrong, I am prepared to apologize. I could not find that it is yet decided. Such a vital question. Which brings me to the next point that I am to flag. And this is in the form of a request. The request is to none other than the Honorable Chief Justice of India. I have always believed that the fundamental duty or the role of the Supreme Court as the apex court, as a constitutional court, as the superior court, as the highest court, is to decide expeditiously on matters of the greatest moment to the country. So I did a little bit of checking up within the limited time that I got. You can also make use of this portal. It's called Jaldi, Jaldi. So the expansion is Justice Access Lowering Delays in India. This is actually by the Vidhi Center operating from, I think, Bangalore. So they keep track, they have a tracker. So this portal, I just scrolled and then I found that there are 28 main matters pending before the constitutional benches. That is 5 benches, 6, 7, and then 1, 9, which is perhaps being heard, has been heard. So the average pendency is 2,738 days for disposing of the larger bench matters, the constitution bench matters. 11 cases are pending for the last 1 to 5 years. 6 cases are pending for more than 6 years, up from 6 to 10 years. 6 plus cases are pending over 10 years. So my humble and respectful request is that the Supreme Court must have a permanent constitutional bench. Now, of course, we have increased the number of judges to 38, I am told. Yesterday it has been passed. I reserve my comments on, about that. I may have something to say, but then I will not say anything about it. Because I have a feeling that the way, with my modest stint at the Supreme Court, how the time is taken up by different benches as we sit in benches, unlike the US Supreme Court, where they sit all 9 judges. When you sit in different benches and you don't even know what is happening in the other court. And when SLPs get listed, and each court will have its own understanding, perspective of how to deal with the cases. So one of the problems which I personally feel is that, with the utmost respect, is that, if the inflow of cases are not controlled, because today I am told, from what I could find, is about 93,000 cases are pending. You're talking about the highest court of the land. And, if you have, I am apprehensive whether, by mere increasing the number of judges, the problem of various could be solved. It's a different matter. I mean, I do not know the whole, the inside story of the pros and cons and how the thing was done. This is my individual opinion, and please don't give it too much of, but this aspect, particularly with 38 judges now available, you should have a permanent 5 judges bench to deal with and clear. Look at this constitution bench pending for 10 years almost, as to whether there is power to direct the speaker to take a decision within a timeline. That is not decided. So what happens is that political parties, they will actually, have their defections. If they're on the wrong side, they will, invoke the fact that it is pending, so don't give a direction. But then courts have, as I have indicated, managed to, issue directions to see that it is concluded, despite the matter of factors pending. But I am only saying, as an institutional reform, that the court may consider having a regular constitution bench. Because if you see what happened in England immediately after the Brexit, the speed with which they decided the case. Pakistan, the Supreme Court, how fast they decided the case. Courts in these matters of constitutional importance, they should not allow it, in my view, not beyond a year. Constitution bench matters should be kept pending. This will go a long way in deciding so many other matters, dependent matters, which are also pending on the the result of these cases. So many cases are pending. The third aspect which I would like to flag in my mind and then before you is the spectre of delimitation which is about to unfold. You see, I am bringing up this issue of delimitation because we are discussing the issue of the declaration of the American independence. The central to the Declaration of American Independence is the concept that all governance, all government is justified on the basis of consent of the governed. Now, in our constitution also, there is a provision which mandates that the number of representatives will depend upon the population. So we had this population, and it was the 1971 census was done, and they realized that, if normally the right time, apposite time to go in for census and then fix it, because there will be grave imbalance. So if we are going to do it now, the concern of particularly the southern states is that if you were to have a census and then prepare the number of representatives to be chosen, you will have a completely skewed, imbalanced, disproportionately imbalanced situation where the votes of the people in the southern states would be of little value relatively. Being of little value equally means in substance that the proceedings in the parliament will actually be of little meaning to us, and then it must be taken that we are not giving our consent to it. This is how I am trying to understand it. So I would think that a solution must be found, because while at this I just wanted to bring in a little two new aspects to the US Constitution which I found, which you should think about and ponder. See, we have indirect democracy in India because our legislators make law. In the US, you have what is called voter initiative. What is voter initiative is exemplified by the judgment of the Supreme Court in Arizona State Legislature versus Arizona State Election Commission, decided in 2015 by a majority of 5-4, majority opinion by Justice Ruth Bader. So there, the voters went and actually wanted to amend the state constitution, which actually provided power to the state legislature to redraw the districts for the purpose of preparing the voters list. So it's called the voters initiative. The voters initiative actually is put to vote without recourse to the assembly, and the constitution itself was amended, and the power was actually conferred on the Arizona State Election Commission, which was a respondent before the Supreme Court. The Supreme Court upheld the voters initiative, repelling the argument that it violated the election clause in the American Constitution, which said that the legislature must actually provide for. They said that the legislature is actually providing in this manner. They can even, for amending the constitution, state constitution, they require the consent of the voters, except in Delaware, in one of the states. This is one of the things, the voter initiative, which, I don't know whether we can have. The other thing which struck me, which I thought I should share with you, was what is called the Administrative Procedure Act, Federal Administrative Procedure Act, Section 553. Now, normally in our country, if you come to the court and say, kindly issue a mandamus and direct that a rule be made, you will say that is exercise of legislative power, you will be told off the gates. In America, this particular provision gives a right to a citizen to petition the concerned administrative authority to issue a rule, amend a rule, repeal a rule. Now, this is traced historically to the petition of right, which was given under the Magna Carta and also reiterated in the under the Glorious Revolution in the Bill of Rights in 1889, and what is more part of the First Amendment to the Constitution. It's called the petition of right. The Supreme Court has said that includes actually the right to petition the court. We don't have a counterpart here, but it would be a good idea if citizens could be asked, could be empowered to actually make a move, because there are several cases where there are rules which stand in the way of actually the progress that we would otherwise be making. The fourth aspect is the dwindling democratic space in our country, and I'm talking about this in the context of liberty, in the context of free speech. We don't have free speech as it's available in the United States, we have it in a truncated form, as you know, under 19.1, read with 19.2, and so many laws we have. But I am really concerned about the way the majority of, the national media houses that I get to listen, how it reveals a close, inextricable link between the business houses and the media. How they completely destroy otherwise healthy discourse which should happen. Now, why I say a healthy discourse which should happen is, the Supreme Court of India has held that the right to be informed is a necessary part for a citizen to exercise his right to express his opinion. If you do not have information, we will not be in a position to participate in the democratic process. So for which today, the power to gather data is with the large media houses, which individual citizens cannot obviously have. So instead of actually supplying us with impartial data, now what do I mean by impartial data? Impartial data is in the course of a debate, if an anchor, instead of actually allowing a level playing ground to all the participants in the discourse, will actually, manipulate the discourse in such a way that it not only reveals the bias of the anchor, it leaves the listener in a quandary as to what is the truth. And the ultimate right of every citizen in any democracy is to pursue truth and find truth. This is the fundamental thing of any democracy, any society. This is sadly missing, is what I am just, pouring out my heart before you, because I watch every day with the hope that they change. But because we have, again, the carrot and stick, I am told, where the media houses are given advertisements, so it constitutes large part of the revenue. And I find this recent trend, you find advertisements, and suddenly you have the Chief Minister coming and saying he's doing so many things. And you will get to know, if you closely watch, at the left-hand top, there is a small www. And then you will know, this is not the real thing. It is actually it's a sponsored program. So this is how it is happening. I really wish the authorities will take notice, because we do have a broadcasting authority, but keeping in mind, the right to freedom of speech and press and all that, nobody wants to take up, because there is one way I have actually thought of dealing with it. In Kaushal Kishore versus State of UP, the Constitution Bench of the Supreme Court has held that Articles 19 and 21 have not only vertical operation, but it also has horizontal application, which means that if a person is complaining of violation of Article 19 or 21 by a fellow citizen, then it is open to him to seek relief. So if the media house, for example, I am invited to a debate, and if I am actually snuffed out, if what I want to say I am not permitted to say, I am tortured out of shape in what I have said, all of this, in my view, constitutes a gross violation of Article 19, the right of the person who is participating and the right of the audience, which is wanting to find out what are they saying actually. So this is one, way out is what, it struck me, and I thought I should share it with you. The penultimate, thing which I would like to talk about is the judiciary. No, I will only say that the 3 judges' cases were actually conducted, the points debated with only one aim. And the aim was to free judiciary from the stranglehold which it might otherwise obtain in the matter of appointment, so that you can appoint the very best, nothing less than the best. When I say the very best, it includes a bouquet of virtues. Just not somebody who's learned. As recently Justice Venkatachalaya in an interview said, If he's a gentleman and if he knows a little bit of law, that is good enough. People who will be fearless and independent, because it'll be transient and momentary and foolhardy for any government to think that if you have somebody who will not really question you when you should be questioned, you have won the day. You may have. But what about the great history we have behind us of finest and noblest and most learned judges? The contributions they have made to the framing of our republic and propping it up, and where we have reached, the contribution is monumental. So my appeal is that when the collegium actually makes a recommendation in terms of the second judge's case, the third judge's case, reiterates the names, let not the central government sit over the proposals which are binding on it, because the words used are ideally it should be they should be appointed, but it should be understood that they should be appointed if it, unless there is some really good cause which stands in the way and which is germane and relevant to the appointment of the judge. My fervent appeal is that this discord, this disharmony between the center and the state and the judiciary should be cleared at the earliest, so that you get the finest judges. Because judging is not an easy process. The kind of docket exploration that has taken place, 22 statutes have been passed by the central government, by which it has vested appellate jurisdiction on the Supreme Court, original jurisdiction on the Supreme Court, original appellate jurisdiction, not contemplated under the Constitution. Judges sit and work under such great pressure. And ultimately, I speak this for the reason that we are discussing the Bill of Declaration of Rights. Under the American realist school of thought, what is law is what the courts say the law is. So if the final court of the highest court is not enabled by it being constituted of the very best in the country, no other consideration, you will have a situation which certainly I can't even think of. The last point which I would like to point is something which I have shared with the Advocate General, and that is about rule of law. We talk always about rights. We talk about what we should get, and what about our duties? I will give a couple of examples. You look at the way our people actually negotiate the traffic signs. If no right turn, 99% they will actually violate it, so long as the policeman doesn't do anything. Have we, after 75 years, not evolved to a stage where we obey laws for what they are worth, without somebody policing you, without the fear of oversight that you will be hauled up? This is the hallmark of a developed country, not that you are third in the GDP, which of course we have slipped down to the 6th position today. It is not GDP actually. It is gross national happiness, the other way of looking at it, what Amartya Sen actually, in one of his books, he has spoken about theory of opportunities. So I would say along with this that the declaration is an eternal reminder to unending generations of mankind that whether you are freeing yourself from an occupying colonizer, or whether, like in France, the problems are against your own government, let the rulers be reminded that you have no heavenly right to rule, your right to rule comes from the fact that we have agreed to be ruled by you. And that we have rights. And these rights may come under a shadow, may be eclipsed, but they will emerge even stronger the more you suppress. So I would think that with these few words, and thank you for your patience, I must end. Jai Hind.